All right. Good morning, everyone. Before we begin, are there any cases that council wishes to call out of order or in any special order?
Good morning, Your Honor. Darby Phelps for the state. I don't have any special requests regarding order this morning.
Good morning, Ms. Cook. Any special requests?
Your Honor, I would ask to trail Garcia and Garcia Karami and Mr. Di Benedetto.
Yes. I'll have the clerk make that adjustment and then I will call the cases in the order they appear on my calendar.
And Your Honor, I also wanted to let the court know it's my understanding that the state is going to request a continuance for victim contact for one of the cases, Mr. Hunter Gonzalez, and deputies have already taken him back to his cell based on that email that I received from Ms. Phelps.
And that's RCR 2025-132466, Ms. Phelps?
That's correct, Your Honor.
Call that case.
Good morning, Your Honor. This is the court interpreter Spanish. Is there anybody that needs my services?
There are no Spanish speakers.
Thank you. Thank you so much.
Thank you very much. Can you confirm that, Mandy? We don't have any Spanish language interpreter cases.
That is correct.
All
Okay,
right.
Your Honor. Thank you so much.
You're free to leave. Thank you for being here.
Thank you.
And let's call the Hunter Gonzalez case into the record. Ms. Phelps, is that correct? You're seeking a continuance to comply with Marcy's law?
Yes, thank you, Your Honor. The state is requesting a one-day continuance to attempt to make victim contact.
And Ms. Cook, any objection?
No, Your Honor.
That's Garcia or Gonzalez.
It's RCR 2025-132466. So that matter will be continued until tomorrow's calendar. The next case on my calendar is Frank Cheshire for two cases. First case ending in 847 and the second case ending in 848.
And Your Honor, Mr. Chesser's cases, I was unable to speak with him this morning. I would request to continue until tomorrow to see if whoever's here tomorrow has better luck with him.
Let's see. Looks like he also did not complete the application for the public defender's office. So perhaps whoever speaks to him can address completing that application should he wish to apply for the public defender's office. We will continue both Mr. Cheshire's cases until tomorrow's calendar.
Thank you, Your Honor.
The next case is Antonio Rodriguez, RPC 2026-067826.
I'm here. I was hoping to get OR today because I have a job and kids to come to.
Hold on, Mr. Rodriguez. Public Defender's Office has been appointed to represent him. Let's start with the position of the state regarding his custody status.
Thank you, Your Honor. So first of all, Your Honor, even if the court were to release Mr. Rodriguez, which in the state's position is not appropriate, he does have 2 outside jurisdiction probation violation holds, so he's not going anywhere. But the state is requesting $15,000 bail on this case with pretrial services supervision. He scores a 10 on the risk assessment. As I just mentioned, he does have 2 other holds. He's got a couple of things going on in 2025. He's got a misdemeanor conviction for resisting. He's got a felony arrest for motor vehicle burg 2+, 4 counts of that out of Eureka County with no disposition. I imagine that case is probably pending still, given those outside jurisdiction holds. He does also have a felony arrest for residential burglary with no disposition out of Eureka County in 2025. He's got a gross misdemeanor conviction in 2023 for open and gross lewdness. Per his 2023 PSI, he has 5 prior felony convictions, a 2020 attempted battery by a prisoner, a 2020 eluding, 2015 theft, means of transportation, and a 2016 burglary conviction. He also has 3 gross misdemeanor convictions for unlawful taking of a motor vehicle, 2020, 2019, and 2017, respectively. So he has a lengthy history as it relates to thefts regarding motor vehicles. As I mentioned, he does have a case with motor vehicle burg with 4 counts of that out of Eureka County from last year. And again, that case has no disposition. I would note the likelihood of conviction in this case. The reporting party watched the defendant enter the victim's Jeep, and then he took the can of Skull and took off. So the state is requesting bail in the amount of $15,000 with pretrial services supervision.
And those other holds, Ms. Phelps, are out of Eureka County, Nevada or California?
So, Your Honor, I'm not sure about that. It doesn't specify. I think it's Nevada, though. When I looked at his criminal history, I believe it was Eureka County, Nevada.
Thank you. Ms. Cook?
Thank you, Your Honor. In speaking with Mr. Rodriguez, who is unable to afford any amount of monetary bail in this case, we would be asking for his release on his own recognizance. As indicated, he does have those PMP
Also have a
holds.
job to get to and stuff.
In speaking with him, although he has just moved to Reno about 6 weeks ago, he is from Nevada. He had been staying at the Wonder Lodge, but he does have available stable housing if he were released from custody. In addition, he has been recently offered employment at TLC, and so also is requesting to be released on his own recognizance in order to, as quickly as possible, get out of custody and clear up those other holds so that he can keep the employment that he was recently able to obtain.
Thank you. Anything further?
No, Your Honor, thank you.
The court has considered the arguments of the parties and finds at this time that it is appropriate to set a monetary amount of bail, given the risk assessment score, the risk of non-appearance, and the risk to reoffend. He's pending 2 holds currently. However, I will reduce the amount sought. Bail will be set at $5,000 by surety or 10%. If he posts, he's not to possess a firearm or weapon, and he shall check in with pretrial services for monitoring only.
All right, Rodriguez.
His next court date will be?
It'll be a 72-hour hearing on July 17th.
The next case is Delano Rogers. This is RPC 2026-067844. Upon application, the public defender's office has been appointed to represent Mr. Rogers. Are the parties prepared to proceed?
Yes, thank you, Your Honor. So, Your Honor, we were able to make contact with the named victim, the defendant's wife, this morning. She says she does want a no contact order. She indicated she did get a TPO yesterday. She does have safety concerns. She says she's very concerned about his mental health. She advised that he is normally an extremely peaceful person. She said the change in him during these episodes is frightening, and it sounds like he does have some mental health issues. It looks like, let's see. She says he does not have any drug or alcohol issues, and it looks like she is making arrangements, alternative living arrangements. So, Your Honor, Mr. Rogers scores a 5 on the risk assessment. He has no prior documented criminal history. For that reason, the state's not objecting to an own recognizance release for him with pretrial services supervision. I would request the conditions of no contact with his wife, Jaquel, and their minor child with the initials ES. And I would also request the condition that he comply with HSA conditions.
Thank you, Ms. Phelps. Ms. Cook?
Thank you, Your Honor. In regards to that request, I don't have any objection to that. I would just like to request that the no contact with the minor be fashioned in such that if there is case planning or supervision as allowed by Human Services Agency, that he be allowed to have contact with the minor child pursuant to whatever that agency's requirements, supervision, or rules are.
Mr. Rogers, the court is going to grant you an own recognizance release in this case based on your promise to appear at your next court hearing. The court is going to impose the following conditions. There will be a no contact order with Jaquel Stratton. That is both by court order and pursuant to NRS 178.4845. You must stay 100 feet from the named party. Do not contact or attempt to contact in any way, including by person, phone, text, email, electronic means, or through social media, either directly or through a third-party agent, with the exception of complying with the Human Services Agency regarding contact with the minor child or facilitating visitation through family, is it Family Wizard or some sort of application that allows for the facilitation of visitation with a child. And Ms. Phelps, it was your request to have that pursuant to statute. Is that correct?
Yes, Your Honor, that's correct.
For the full 120 days?
Yes, Your Honor, and if Ms. Stratton feels like she no longer needs that, she can apply to the court to have that lifted.
All right. So I've included, Ms. Cook, in the order the exception for the Human Services Agency regarding contact with a child. If there's any issue with that language, bring it back before the court so we can modify it as necessary. The intent of the release condition is to allow visitation under the supervision of the Human Services Agency as they deem appropriate. His next court date will be.
That'll be an arraignment on July 29th at 9:30.
Thank you. That concludes this case.
Thank you so much, Your Honor.
The next case is Adria Stump. This is RPC 2026-067851.
And Your Honor, Ms. Stump is not present this morning. I did have the opportunity to speak with her. I do feel prepared to move forward. And just for the court's information, she did have a June 22nd, 2026 finding of incompetency in Reno Municipal Court and case dismissed. So I imagine that once a criminal complaint is filed in this matter, if one is, we will be going that route as well.
Understood. The public defender was appointed, so let's proceed with the case. What's the state's position regarding her custody status?
Thank you, Your Honor. So the state's position is that bail is appropriate. In this case, I would request bail in the amount of $3,000 with pretrial services supervision and no contact with the subject apartment complex at 525 Morrill Avenue. Now, so Your Honor, typically on these cases, absent some egregious history of failures to appear and recent criminal history, the state typically, at least as far as I'm concerned, I typically don't object to an own recognizance release. But for Miss Stump, she just has too much recent history. Already this year, she's got misdemeanor arrests, multiple of them resisting, possession of drug paraphernalia, another resisting, 2 failure to appear arrests already this year. 2025 looks like I count 3 failure to appear arrests. She's got misdemeanor convictions in 2025 as well, battery, resisting, littering, contempt, and then her history just goes on and on and on from there. So due to the very high risk of future non-appearance, I think she gets released. I think there's zero chance she appears, and continued criminal conduct. The state does believe that the $3,000 bail is appropriate.
Well, don't worry about it. I'm sure. Okay. They know I'm not Judge Birchie.
Okay. Oh, I'm working out the kinks. That's okay.
Oh, I'm sorry. The clerk just informed me the placard's incorrect on the video. She wanted to take a recess, but I think we can proceed. Anything further, Ms. Phelps? I heard the request for 3,000 with 10% bondable. Based on
No, Your
that,
Honor, nothing further from the state.
All right, Ms. Cook.
Thank you, Your Honor. And speaking with Ms. Stump this morning, she indicates residing in this area for her entire life. She is currently unhoused and does not have any means to afford any amount of monetary bail. She is currently reliant on community resources from the homeless shelters in order to survive. She previously, as I mentioned before, has had competency issues very recently. And so based off of her inability to afford any monetary bail, I would request that she be released on her own recognizance with check-ins at Reno Justice Court to ensure her future appearance at court.
Thank you. The court will find at this time that the defendant poses a risk of non-appearance given numerous failures to appear within the last 24 months, scored a 13 on the risk assessment score. Therefore, the court finds that she is a risk to fail to appear for future hearings, and a monetary amount of bail is appropriate in this case. Bail will be set at $1,000 by surety or 10%. She's to have no contact with Juniper Village Apartments. And she will be subject to RJC monitoring if she posts. That means to check in with Reno Justice Court within 1 business day of release. And her next court date will be a 72-hour.
Yep, on July 17th.
Next case is Daniel Gonzalez. RPC 2026-067-837. The public defender's office has been appointed. What's the position of the state, Ms. Phelps?
Thank you, Your Honor. So I don't see any criminal history for Mr. Gonzalez in the last couple of years. I do recognize that he scores a 10 on the risk assessment, but given the lack of recent criminal history and the low amount of suspected methamphetamine in this case, the state's not going to object to an own recognizance release for Mr. Gonzalez with pretrial services supervision with testing for controlled substances.
I'm prepared to release him on his own recognizance with conditions. Ms. Cook, do you wish to be heard further?
No, Your Honor.
Mr. Gonzalez, the court is going to release you on your promise to appear with conditions. The conditions being that you must check in with pretrial services following your release, and you will be subject to random testing through pretrial services.
Yes, Your Honor.
Your next court date will be
That'll be an arraignment on July 29th at 9 a.m.
Make sure you appear at that date or a warrant could issue for your arrest, and make sure you meet with your public defender in the interim, all right?
Yes, ma'am.
The next case is Christopher Holland, followed by Martha Holland. Mr. Holland appears. The public defender's office has been appointed. What's the state's position, Ms. Phelps?
Thank you, Your Honor. The state's not objecting to an unrecognizance release for Mr. Holland. He scores a 3 on the risk assessment. The state would request pretrial services supervision and the condition that he comply with HSA conditions.
Ms. Cook, does the defense wish to be heard further regarding Mr. Holland's
Your
custody
Honor.
status?
No, Your Honor.
And Ms. Phelps, I heard the request for supervision is just monitoring only with pretrial services.
That would be fine, Your Honor.
Mr. Holland, the court is going to release you on your own recognizance with the following conditions. You need to comply with the Human Services Agency, and you're to check in with pretrial services following your release, all right?
Okay.
Your next court date will be an arraignment.
That'll be July 29th at 9 a.m.
Thank you.
Thank you. Next case is Martha Holland. RPC 2026-067840. Public defender has also been appointed in this case, although I presume the alternate may need to step in. Are the parties prepared to proceed?
Yes, Your Honor. So Ms. Holland scores a 2 on the risk assessment. The state's not objecting to an unrecognizance release for her with pretrial services monitoring and comply with HSA conditions.
And Ms. Cook, are you able to stand in and represent Ms. Holland for the purposes of the bail hearing?
Yes, Your Honor.
The court's prepared to release her on an own recognizance release with conditions. Do you wish to be heard further?
No, Your Honor, I think owner cognizance release with those conditions are appropriate.
Ms. Holland, the court is going to release you on your promise to appear at your next court date. You need to abide by the following conditions. Check in with pretrial services following your release and comply with the Human Services Agency
Yes, Your Honor.
regarding the investigation with the children, all right?
Yes, Your Honor.
Your next court date will be an arraignment, and that'll be July 29th?
Yes.
July 29th at 9 a.m.
Thank you, Your Honor.
Thank you. Next is Jermaine Means. That's RPC 2026-067843. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Public defender's been appointed. What's the position of the state, Ms. Phelps?
Thank you, Your Honor. So, Your Honor, we were able to make contact with the named victim this morning. She indicated to us that she does want a no contact order. She is afraid for her safety. She says the defendant is regularly violent when he gets upset and doesn't get his way. She says she was just waking up when we called her and wouldn't really expand on how he's violent. However, he does have a documented history with our office. So let's see, she described the previous case, which I'll also get into detail with Your Honor. It sounds like the frequency of his violence can vary depending. She describes sometimes it can be daily, depending on what's going on. It appears that she wants nothing to do with him anymore. She says that he does have a drug and alcohol problem. She says his drug of choice is methamphetamine, but it sounds like he has issues with both drugs and alcohol and possibly mental health issues as well. She says he doesn't have any weapons, and she does not intend to participate in the bail hearing this morning. So, Your Honor, Mr. Means scores a 13 on the risk assessment. This case involves the same alleged victim as his prior case, that being a 2023 felony conviction for domestic battery resulting in substantial bodily harm. In that case, he bit her on the face so hard her skin and muscle peeled back on her eyebrow and her skull was visible. He does have a non-extraditable warrant out of California for domestic battery. The date of warrant on that case is May of 2017. Per his 2023 PSI, he has 5 prior felony convictions, 6 if you're including that 2023 domestic resulting in substantial bodily harm. He's got 3 gross misdemeanor convictions, at least 52 misdemeanor convictions, and numerous failures to appear. A sampling of his criminal history is as follows. He's got significant history as it relates to violence. He's got a 2018 gross misdemeanor conviction for battery by a prisoner, a 2015 felony conviction for domestic battery out of California. In that case, his probation was revoked 5 times, and that case was at warrant when he picked up that 2023 domestic. It appears that's the case for which he still has a non-extraditable warrant out of California. He's got a 2011 felony conviction for domestic battery out of California. His probation was revoked in that case, and he was sent to prison. He's got a 2008 felony conviction for transporting or selling a controlled substance, a 2007 gross misdemeanor conviction for conspiracy to commit battery resulting in substantial bodily harm, 2006 felony conviction for unlawful sales of a controlled substance. He's got a gross misdemeanor conviction for escape in 2003, a misdemeanor conviction for domestic battery in 2002, and a felony conviction for trafficking in a controlled substance in 1995, for which he was sentenced to 10 years in prison. So, as Your Honor's just heard, he has 6 prior felony convictions, including 3 prior felony convictions for domestic violence, and 1 from a few years ago where he caused serious injury to the same victim, as alleged in this case. I would point out that there are witnesses in this case as well, so it's not just a he said, she said. We've got a couple of other witnesses who actually had to peel the defendant off of the victim in this case. There are clearly no conditions that will protect the community, especially the victim in this case, from this defendant. And to that end, the state's requesting a large monetary bail. I do think a detention level bail is appropriate. The state's requesting bail in the amount of $100,000, bondable only, pretrial services supervision if he somehow is able to post, absolutely no contact with the victim as a condition and pursuant to statute, and no firearms or weapons.
Thank you. Position of defense.
Thank you, Your Honor. And speaking with Mr. Means this morning, he is unable to afford any amount of monetary bail, especially the high level that has been requested by the state. He has been in this area for a significant period of time, although although he was residing at the place where he was arrested from, understanding that if there's no contact order put in place, he does have an alternative residence at which he can stay. He does have a phone number as well that he can be reached at in regards to pretrial services, check-ins, as well as maintaining contact with the court and his attorney to ensure all of his future appearances at any court dates. In this situation, Your Honor, there are pretrial conditions that could be put in place, specifically the no contact order as has been requested by the state in order to ensure safety of the alleged victim. In regards to that, he would also be willing to comply with whatever other pretrial release conditions that the court might deem appropriate, and based off of his history or the nature of the allegations in this case. And with that, we would submit.
Thank you. The court does find at this time that the state has met its burden by clear and convincing evidence to establish that the defendant poses a risk of safety to the community, a particular risk of safety to the named alleged victim in this case, that there is a concern of additional criminal activity should the defendant be released. The court makes that finding based on a number of prior violent crimes, prior violent offenses involving the same alleged victim in this case. He scored on the higher side for the risk assessment. For all those reasons, the court is going to impose conditions and monetary bail. Bail will be set at $75,000 by surety or 10%. He's to have no contact with Oda Ward and the address located at 1233 East 4th Street, number 31. You must, and that's effective immediately, sir. You must stay 100 feet from the named victim. Do not contact or attempt to contact in any way, including by person, phone, text, email, electronic means, or through social media, either directly or through an agent. And that applies, again, right now. So including communications from the Washoe County Detention Facility. You're not to possess a firearm or weapon. If you're able to post, you'll be subject to supervision by pretrial services. And that includes supervision level required to check in as determined by pretrial services. You must check in within 1 business day of release. And his next court date will be a 72-hour hearing on July 17th.
And Your Honor, just to clarify, I believe I heard you say $75,000 bondable or 10%. This is a Category B felony with a human victim.
And it's by surety only pursuant to the administrative order.
Thank you, Your Honor.
Thank you. Next case is Daniel Ruiz, RPC 2026-067845. The Ruiz is present. The public defender's office has been appointed. What's the position of the state, Ms. Phelps?
Thank you, Your Honor. So Mr. Ruiz scores a 2 on the risk assessment. He has no prior documented criminal history. The state's not objecting to an unrecognizance release for him with pretrial services supervision with testing for controlled substances and no firearms.
What's the basis for the request for testing?
So, Your Honor, he was arrested with over 7 grams of suspected cocaine that were actually lined up in his car.
Thank you. Position of the defense?
Your Honor, we have no objection to an unrecognizance release with conditions as outlined by the state.
Mr. Ruiz, the court is going to release you on your own recognizance with the following conditions. You will be supervised by pretrial services. You're not to possess a firearm or weapon, and you will be subject to random testing. And the court does find that is based on the probable cause statement. There is a reasonable nexus given the presence of alleged illicit narcotics at the time of arrest. And his next court date will be in arraignment July 29th at 9 a.m. Thank you. Next is Anthony Salazar, followed by Skylar Yanez. Public defender's been appointed to represent Mr. Salazar. What's the position of the state?
Thank you, Your Honor. So I was just reviewing the notes. We were able to make contact with the named victim this morning. She stressed to us the importance of the defendant staying in custody until he gets transported to some sort of inpatient program. She believes that's what he needs to live a clean and sober, obviously, and crime-free life. Looks like the halfway house where he's staying, she says it's not working. She definitely wants a no contact order, but she is hoping that he stays in custody. She's very concerned for her safety, the safety of her family. She says that Mr. Salazar is unpredictable because of his drinking, drugs, and because of his drinking. She says alcohol is definitely his drug of choice. She doesn't know whether he uses other controlled substances. She says that their mother has early onset dementia and will leave the house willingly with him when he's drunk because she doesn't know any better. He'll take her to hotels and has even stayed at the CARES campus with her, which the victim believes puts their mother in danger. Looks like he's been trespassed numerous times from the victim's residence in the past because of his behavior, and he's been what she describes as a constant nuisance. So, Your Honor, he does score a 13 on the risk assessment with 2 points for violent criminal convictions. He's got a felony conviction in 2024 for home invasion. He was sentenced to prison in that case, 19 to 48 months. He's got a couple of violent criminal convictions in 2023, one for domestic battery, one for battery. And then in 2022, he's got a DUI conviction. He had a pretrial failure to appear warrant in that case and 2 post-sentencing failure to comply warrants. He's got some additional misdemeanor history, looks like a resisting in 2020, a battery in 2019. He's got another felony conviction, attempted home invasion in 2016. In that case, his probation was revoked. And then in 2010, a felony conviction for possession of a controlled substance while armed. In that case, his probation was revoked as well. So the state is requesting bail in the amount of $5,000 with pretrial services supervision, no contact with the victim and her residence as a condition and pursuant to statute, and no firearms or weapons. Based on the victim's request and belief that inpatient would be appropriate, the state wouldn't object to an alternative of an own recognizance release with direct transport to an inpatient facility.
And just to clarify, Ms. Phelps, the named victim is last name Quintanilla?
That's
And
correct,
the
Your
address
Honor.
would be the 1902 Watt Street.
I believe that's correct, Your Honor. I'll verify that right now.
Your Honor, I believe that the address is the Lynx address in North Reno, in the 89506 business.
All right, that's what I was trying to clarify. So it's the 1317 Link Street.
Yes, ma'am. Yes, Your Honor.
All right. And what's the defense position, Ms. Cook, on his custody status and the state's acquiescence to direct transport to an inpatient facility?
Your Honor, in regards to Mr. Salazar's case, we would ask that he be released on his own recognizance. I know that obviously it's a concern to allege to have violated a protection order. and especially when there are family dynamics at play. I believe this incident may have been a misunderstanding on Mr. Salazar's part. And I would note in the probable cause that it seemed as if, at least initially, his sister was somewhat gracious and offered to give him a ride someplace to avoid getting law enforcement involved, as she did not want him to go to jail. In speaking with Mr. Salazar, he was previously at Well Care. That's the halfway house that the sister is referring to. He checked himself into that program. He was not court ordered to do so, and has the ability to return there. In addition to that, once he has completed that program, he does have another residence that is separate and away from Miss Quintanilla, a residence where he is not, there's no requirement that he stay away from that address. He has lived at that address for 20 years and has been in Reno for 27 years. He is currently not working, but like I stated, was working his way through that Well Care program. I think that with Mr. Salazar continuing in that program as opposed to remaining in custody and possibly losing access to the service that he already is engaged in, would be more beneficial, not only to him, but community safety as well. And so I would ask the court to release him on his own recognizance. He can submit to testing given sister's stated concerns about the alcohol use, with that no contact and stay away order of her and her residence.
Thank you. The court has considered the arguments of the parties. Notes for the record that the risk assessment is a 13 in this case. The court will find at this time the state has established by clear and convincing evidence it is necessary to impose both conditions and a monetary amount of bail. Court notes prior failure to appear history as stated, as well as a number of prior violent offenses. Therefore, the court is concerned and finds that the defendant poses a risk of safety to the community, to the named alleged victim in this case, and a risk of non-appearance. Bail will be set at $5,000 by surety or 10% with the following conditions. He's to have no contact with 1317 Link Street in Reno and Antonia Quintanilla. That's both by court order and pursuant to NRS 178.4845 for 120 days, and it is effective immediately. Mr. Salazar, you must not contact and must stay 100 feet from Ms. Quintanilla. That includes contact by person, phone, text, email, electronic means, or through social media, either directly or through an agent. You're not to possess a firearm or weapon. And you'll be subject to supervision by pretrial services by monitoring only. Or you may be directly transported to a suitable inpatient facility through the Inmate Assistance Program. His next court date will be a 72-hour hearing on July 17th. Thank you. Next is Skylar Yanez, followed by Prier. Like Mr. Yanez did not qualify for the public defender's office. Mr. Yanez, are you seeking to hire a lawyer to represent you?
Yeah. Or I could, I don't know, I'm not sure what to do in this situation, I guess.
Do you have someone that you've already hired?
For a previous case, yes. But not currently.
So we can move forward today and the public defender's office can stand in perhaps if you wish. Or I can set this over until tomorrow if you're seeking to have private counsel appear with you that you've retained.
The public defender could step in.
Ms. Cook, would you be willing to stand in for the purposes of today's bail hearing only to assist Mr. Yanez?
Yes, Your Honor.
Thank you very much. Then let's proceed with the hearing. Ms. Phelps, what's the state's position on his custody status?
Thank you, Your Honor. So ordinarily, when we get a DUI case, DUI first with speeding, it's ordinarily going to be an own recognizance release. In fact, they're usually released prior to even having a hearing. But in this case, that didn't happen for Mr. Yanez because he was just convicted of a gross misdemeanor aim firearm at a person earlier this year. I believe it was in February. And so I believe he does have a P&P hold. He was ordered to have no drugs or alcohol as a condition of his probation. And he admitted in this case to having been drinking beer. So he's already not complying with conditions that another court has imposed upon him as a condition of probation to prevent going to jail for a year. So the state doesn't believe that an own recognizance release is appropriate for Mr. Yanez. To that end, the state is requesting bail in the amount of $3,000, which is a moderate amount. I think it's actually a low amount given the situation. With pretrial services supervision, if he's able to post that, which I imagine he will, with testing for drugs and alcohol.
Ms. Cook, what's the position of Mr. Yanez regarding his custody status?
Thank you, Your Honor. In regards to this matter, we are asking that he be released on his own recognizance on this case. He does have that hold out of Department 8 due, I'm assuming, to this arrest as an alleged violation of his probation in that case. So even if he is released on his own recognizance or has the ability to afford bail, if it is ordered, he will remain in custody on that no bail hold until P&P lifts that hold, or unless and until he sees Judge Breslow to, go have a probation violation hearing. So given that, I don't believe that he has any risk of failing to appear or not complying with orders or danger to the community, as, like I stated, he will remain in custody until that hold is resolved. However, specifically in regards to this case, he does score as a moderate risk. This is an allegation of a misdemeanor DUI, and obviously if he is found to have violated his probation, he will have to face those consequences at a later date. But I think specifically related to this incident, he could be released on his own recognizance with appropriate conditions to include testing for alcohol, given the nature of the allegation. He has a very limited history, just that conviction, the gross misdemeanor conviction from earlier this year, and a 2021, it looks like, possession of less than 1 ounce of marijuana. So I don't believe he presents as a huge danger to the community if those conditions are imposed.
Thank you. At this time, the court is going to reluctantly release Mr. Yanez on his own recognizance with conditions. So Mr. Yanez, you're walking on thin ice and you need to abide by the following conditions. Otherwise, the court could reassess your custody status. You understand?
Yes, Your Honor.
You're going to check in with pretrial services and be under their supervision. You're going to be subject to testing for alcohol. And that's going to be alcohol only, as I did not see a nexus for controlled substances testing as well. You to complete the DUI rant through this process. And prior to the next hearing, you can either reapply to screen for the public defender's office if your income has changed, or you need to appear with retained counsel. So make that a priority, all right? Your next court date will be an arraignment on July 29th at 9 a.m.
Thank you, Your Honor.
Next is Creer, followed by Isome. Have a public defender application?
These are just first appearances for fugitives. We just usually sit in 72 hours.
All right, sorry.
It's okay.
There it is. This is a first appearance based upon a warrant out of Arlington, Texas, it appears. Looks like I don't even see if there's an amount. So this is the first appearance. We're going to set a 72-hour hearing for additional information to be received. And then we'll have another court date, ma'am. But your presence is wanted in the state of Texas, and these proceedings are to facilitate extradition to the state of Texas. So we'll talk a little bit more at the next hearing, whether you wish to voluntarily waive your rights to be transported to Texas or if you want to challenge those. But for today, the first appearance has been satisfied as Texas is seeking transfer based upon, looks like some felony charge of child endangerment, and that's dated is that right? 1992.
Yeah, that's all.
Oh no, printed. Looks like it's an existing warrant
Yes, Your Honor, I show a date of warrant.
of 1992.
I show 2024.
I'll take your word for it, Ms. Phelps. The copy that is on my screen is very difficult to read. It's smudged.
So yes, Your Honor, I noticed that I'm actually looking at her NCIC criminal history report. I'm not guaranteeing certainly that it's a 2024 warrant. I was just trying to assist the court with what I see.
All right. So you're not entitled to the public defender's office, but you can retain your own attorney to represent you in these proceedings if you wish. And when will the 72-hour be?
That'll be July 17th at 9:30.
July 17th. Thank you.
Yeah.
What's the next case?
Seth,
Isome?
same case, same type of case.
And is this Mr. Isome?
Yes, Your Honor.
Mr. Isome, this is also a warrant out of a foreign jurisdiction, looks like the Commonwealth of Kentucky. And that is dated out of Carlisle County from May 21st, 2026. We will have a further hearing, including the extradition hearing. You're not entitled to the appointment of the public defender's office in these proceedings. Today is just to inform you of your first appearance based upon the request from the Commonwealth of Kentucky to secure your presence and transport. So once the criminal complaint has been filed, then we'll have a further discussion of your rights and how you wish to proceed. That date will be
We have a 72-hour hearing on July 17th at 9:30.
July 17th at 9:30. Thank you. That leaves next, I have Karami Di Benedetto and Garcia.
Good morning, Your Honor. This is LaDan Dillon, certified Farsi interpreter out of Clark County.
So let's go ahead and call the Karami case.
آقای کرامی.
بله.
Yes.
This is RPC 2026-067841.
داره پرونده‌تون رو میخوره شماره‌شو؟
Mohammed Karami.
محمد کرامی.
بله.
And the record will reflect that we are joined by a Farsi interpreter.
و مترجم زبون فارسی در اختیارتونه.
And Madam Interpreter, have you provided interpretation services in the language of Farsi before?
Yes, Your Honor, about 20 years,
Thank you very much.
of course.
The Public Defender's Office has been appointed to represent Mr. Karami.
وکیل دادگاه برای شما در اختیار شما گذاشته شد.
بله.
Yes.
Is the state prepared to proceed at this time?
از دادستان میپرسه ادامه میدی؟
Yes, Your Honor. So, Your Honor, we've seen a number of these cases in the last couple of days.
دادستان داره میگه چند تا از این کیسا تو این چند روز اخیر اینا دیدن؟
Frequently, defendants on these cases don't have any prior documented criminal history.
و خیلی پیش میاد که اینجور آدما قبلا هیچ پرونده جنایی ندارن.
Nonetheless, the court has set bail, monetary bail, on each case.
ولی دادستان رقم جریمه رو میخواد بذاره برای
Due to the risk to the community.
به خاطر خطری که برای اجتماع هست.
Of course, the bail amount varies depending on the alleged facts and the defendant's personal circumstances.
البته رقم جریمه بستگی داره شرایط خود طرف متهم چیه.
In this case, Mr. Karame scores a 5 on the risk assessment.
تو این مرحله آقای کرامی از لحاظ خطر به اجتماع شماره 5 هستن.
He is a California resident.
ایشون در کالیفرنیا زندگی میکنن.
And he has no prior documented criminal history.
و ایشون هیچ پرونده جنایی ندارن که قبلا بخوان کرده باشن.
However, due to the risk to the community,
ولی به خاطر خطر اجتماع
the state is requesting bail in the amount of $40,000.
دادستان میخواد که برای جلسه صدیقی قرار وثیقه $40,000 باشه.
With pretrial services supervision if he's able to post bail.
و اگر میتونید این رقم رو بپردازید باید تحت نظر دولت باشید.
And no unsupervised contact with minors.
و به هیچ عنوان هیچ تماسی با جوانای که زیر 18 و 21 سال هستن باشید.
What I want to point out with regard to this case is that Mr. Karame did acknowledge that the behavior he was engaging in is wrong.
ولی چیزی که دادستان میخواد الان تکیه بده اینه که آقای کرامی قبول کرد که کاری که کرده اشتباهه.
And so he knew it was wrong, he knew there were consequences, and he did it anyway.
و ایشون میدونست که اشتباهه و میدونست بالاخره یه جریماتی خواهد بود ولی با این حال انجام داد.
It's also important to point out that he is a California resident with no apparent ties to the Washoe County area.
و مهم اینه که ایشون در کالیفرنیا زندگی میکنن و هیچ کسی ها اینجا در واشو کانتی نمیشناسن.
And the likelihood of conviction on these charges is very high.
و محکوم شدن این کارایی که ایشون انجام دادن خیلی بالاه.
For those reasons, the state is requesting bail in the amount of $40,000.
واسه همین دادستان میخواد برای وثیقه $40,000 برای شما بذاره.
And that would be by surety only, Ms. Phelps?
داره میپرسه، قاضی داره میپرسه یعنی به عنوان امانت؟
Yes, Your Honor.
گفتن بله.
Ms. Tush?
Thank you, Your Honor. In regards to this case, we are asking that my client be released on his own recognizance.
حالا وکیل دادگاه که وکیل شماست داره درخواست میکنه که شما را آزاد کنن.
I understand the state's concern related to containing probable cause statement.
و وکیلتون داره میگه که میفهمه که دادستان چرا یه ذره چیز داره.
However, Mr. Karami has no criminal history.
ولی آقای کرامی هیچ پرونده جنایی در گذشته ندارن.
And although he does not reside in California, we were able to speak with his brother.
ولی ما میتونستیم با برادرش در کالیفرنیا صحبت کنیم که ایشون نیستن اونجا.
His brother was able to verify that Mr. Karami does have a stable residence in Rancho Cordova, California.
و برادرشون تایید کرد که ایشون خونه و زندگی دارن در رانچو کوردووا در کالیفرنیا.
Where he would be able to return if he were released from custody.
که ایشون اگه آزاد بشن برمیگردن خونهشون.
He has lived at that residence for over 1 year.
ایشون تو اون خونه بیشتر از 1 سال زندگی میکنن.
And has lived in the Sacramento area for the past 2 years.
و 2 ساله که در محل ساکرامنتو زندگی میکنن.
There are several family members who reside at that residence, according to Mr. Karami's brother.
و برادر آقای کرامی گفتن که چند تا اعضای خانواده تو اون خونه زندگی میکنن.
And they are able to assist to ensure that Mr. Karami complies with whatever pre-trial release conditions and physical appearances and at any future court dates.
و اون اعضای خانواده کمک میکنن که ایشون تمام کارهایی که دادگاه بهشون میگه دستور میده انجام بدن.
We were also able to confirm Mr. Karami's telephone number as well as his employment.
و ما تونستیم تأکید کنیم شماره تلفن آقای کرامی و مکان کارشون.
And so with the information that we were able to verify, his NPRA score would be down to a low risk, and he would only score for age and being a non-Nevada resident.
و ما تونستیم که به این نتیجه برسیم که ریسکشون خیلی پایینه از لحاظ NPRA و فقط به خاطر اینی که از لحاظ سنی و برای اینکه تو نوادا مکان نیستن این جریمه رو بخوایم قبول بکنیم.
We are asking that he be released on his own recognizance due to low risk score, lack of criminal history, stable residence, and employment.
و ما میخوایم درخواست کنیم که ایشون آزاد بشن به خاطر اینکه ریسک خیلی کمه برای اجتماع و به خاطر اینکه کار دارن و مکان دارن.
And we have no issues with pretrial supervision and no unsupervised contact with minors.
و ما هیچ مسئله نداریم که ایشون تحت نظر آدما باشن که هیچ رابطه‌ای با بچه‌های کوچیک نداشته باشن.
Thank you. The court finds at this time that the state has demonstrated by clear and convincing evidence
قاضی داره میگه دادستان تونست ثابت بکنه
there are no non-monetary conditions that would reasonably ensure the defendant's appearance or the safety of the community. Therefore, conditions and a monetary amount of bail is appropriate.
و ما فکر میکنیم که شرایطی که دادستان گذاشته و رقمی که دادستان گذاشته درسته.
I have considered the argument of defense for the reduced NPRA score.
و من وکیل ایشونو حرفشونو در نظر گرفتم که از لحاظ درصد ریسک خیلی پایین هست.
However, the court remains concerned that he has a risk of non-appearance.
ولی قاضی میترسه که وقتی اگه شما را آزاد بکنه شما دادگاه برنگردید.
The court has considered the nature and the seriousness of the charges alleged.
و قاضی داره میگه که این چارجایی که ضد شما شده خیلی سریوس خیلی مهمه.
The apparent likelihood of conviction and prison sentence.
و شانس اینی که ایشون محکوم بشن و زندان برن بالاه.
As those factors pertain to his risk of non-appearance.
و در این حال هم ایشون امکان داره به خاطر این مسئله دادگاه برنگرده.
Bail will be set at $30,000 by surety only.
و وثیقه رقمی که میذارن $30,000 برای ضمانت.
He's to have no unsupervised contact with minor children.
و ایشون حق ندارن به هیچ عنوان هیچ صحبتی یا تماسی با بچه‌های کوچیک داشته باشن.
And he shall be subject to supervision by pretrial services.
و قسمت pretrial services که قبل از دادگاهه باید تحت نظر محافظت اونا باشن.
If he posts, he needs to check in with pretrial services within 1 business day of release.
و اگه تونستید که این پول مقدار رو بپردازید باید در عرض 24 ساعت با این مؤسسه pretrial services تماس بگیرید.
The next court date will be a 72-hour hearing on July 17th.
و دادگاه بعدی 3 روز دیگه است 17 جولای.
Thank you. That concludes this hearing at this time. Thank you, Madam Interpreter.
Thank you, Your Honor. May the interpreter be dismissed?
You may.
Thank you.
The next case is Patrick DiBenedetto. And I apologize if I misstated that name.
DiBenedetto, Your Honor.
Thank you. The Public Defender's Office has been appointed in this case. Let's proceed with the bail hearing. What's the state's position, Ms. Phelps?
Thank you, Your Honor. So For Mr. Di Benedetto, he scores a 2 on the risk assessment, so I was kind of surprised to see on his criminal history, he actually has a bench warrant out of Troutdale, Oregon for encouraging child sex abuse, with the date of warrant being October of 2024. When we look at the charges that he's now booked on, it's very concerning and tends to indicate that he's alleged, at least, to have engaged in this behavior before and actually very recently. In addition to that, he's got a 2017 felony arrest for prohibited person in possession of a firearm. That case, however, was dismissed as the TPO, which prohibited him from possessing a firearm, had been dissolved. So I'm not asking the court to consider that case, but I'm certainly asking the court to consider that bench warrant out of Troutdale, Oregon, for what sounds like a very similar offense. Now, an offense like this warrants bail, in the state's opinion, monetary bail in any event, with no criminal history, with no warrants for a similar offense. And Judge Pearson, I won't try to repeat the story that he always tells, but essentially, in essence, there's really no conditions that this court can impose to ensure the safety of the community. There's no way for the court to meaningfully monitor any electronic devices he has. And even if the court could do that, the defendant could simply just go out and get a different electronic device through which he could engage in this very abhorrent and dangerous behavior. So the state is asking for a detention level monetary bail with the understanding that there's really nothing this court can do to protect the safety of the community, especially innocent young children. So the state is requesting bail in the amount of $300,000, bondable only, with pretrial services supervision if he is able to post that, and absolutely no contact with minor children.
Position of defense.
Thank you, Your Honor. In regards to this case, my client is not able to afford any monetary bail. He has lived in this area consistently now for the past 2 years. Before that was residing in Oklahoma due to his father passing away, but has spent the majority of his life between here in Northern California and Las Vegas. He does have a residence where he has lived since August 30th of 2025. He is currently unemployed, however, has very limited means as his significant others. Currently the sole source of support, she receives disability. And so the amount obviously is a very fixed amount. We were able to speak with his girlfriend, who did confirm that address, who indicated that he is welcome to return there. He did have a phone, obviously, as indicated by the probable cause that was seized and taken into evidence due to this case, or I guess actually the prior case, and is now in evidence and related to this case. He also does have other extended family in the area. His mother also resides in Reno, and he does have 2 siblings who reside in Silver Springs. So he does have other ties to this community. And so we are asking again for his release on his own recognizance, given his inability to afford the limited amount of income that he and his girlfriend currently have, as they are currently just relying on on her disability. She indicates that she is hoping that he can be released because he needs to get back to work as soon as possible in order to help contribute to the household expenses.
Thank you. The court has considered the arguments of the parties and recognizes the risk assessment came back as a lower risk. However, there is the existence of a warrant out of the sister jurisdiction for the same or similar alleged conduct. The court will find at this time that the state has met its burden by clear and convincing evidence to establish that there are no conditions that can satisfy no non-monetary conditions to satisfy both the defendant's appearance and mitigate his risk of danger to the community. The court has considered the nature of the offense. It's a category B felony, as well as the likelihood of conviction as it pertains to his risk of non-appearance, the significant risk of harm to the most vulnerable segment of our community, which is children. Therefore, the court finds that it is necessary to impose monetary bail and conditions in this case. Bail will be set at $100,000 by surety only. He's to have no unsupervised contact with minor children. He will submit to supervision by pretrial services if he posts. That would be within 1 business day of release. His next court date will be a 72-hour hearing on July 17th. Thank you. And that leaves Mr. Garcia. This is RPC 2026-067836. Public defender's been appointed in this case. What's the position of the state, Ms. Phelps?
Thank you, Your Honor. I'm just trying to find his information on my little sheet. Okay, here it is. So, Your Honor, this is Mr. Ignacio Garcia, correct?
Yes, ma'am.
That's correct.
Okay, thank you. So, Your Honor, the state's requesting bail in the amount of $3,000 for Mr. Garcia with pretrial services supervision with testing for controlled substances. He scores a 15 on the risk assessment, but it should be a 16 because he was also booked on a failure to appear warrant. Looks like he's got a misdemeanor conviction this year for possession of drug paraphernalia. He's got a pretty significant criminal history as it relates to felonies, and looks like he's got several felony convictions for failing to register as a sex offender, 1 in 2021, 1 in 2006. Looks like a felony conviction for assault with a deadly weapon in 2021 as well, a trafficking controlled substances felony conviction in 2008, and then he's got his underlying sex offense felony conviction for statutory sexual seduction back in 2004. But due to that very high risk assessment score, which by my math should be a 16, which puts him just 1 point below the maximum score, he is a high risk of both continued criminal conduct and future non-appearance. So the state's requesting $3,000 bail with pretrial services supervision with testing for controlled substances if he's able to post.
Thank you. Position of the defense.
Thank you, Your Honor. In Mr. Garcia's case, we are asking that he be released on his own recognizance. I know that he has, some history related to lots of different things, which may be concerning for ongoing criminal conduct. However, he does have a hold out of Reno Municipal Court for the failure to appear that the state mentioned is a $448 hold for a possession of drug paraphernalia citation from 2024. It looks like he missed his arraignment on that case. And so in speaking with Mr. Garcia, he's not able to afford that amount. In addition to that, Your Honor, he also does have a no bail parole hold. And so, you know, he will remain in custody unless and until that hold is lifted or he goes in front of the Board of Commissioners to address any alleged violations from PNP. So again, you know, even if he is released on his own recognizance in this case, he still has those other 2 holds that will keep him in custody for some period of time. And speaking with Mr. Garcia, he has been in the area for 20 years. He would go back to the Kitsky Lane address, which is the address that he was most recently registered at. He lives there with his sister. And so I think that clears up the issue with the convicted person failure to register charge. In addition to that, he does have employment for the past 2 months working at Concrete Square 1. He also does have a phone number where he can be reached by the court for check-ins and testing. In addition to that, Your Honor, it was less than 1 gross gram weight of alleged methamphetamine that was located after he agreed to be searched. And so I'm not sure if that would end up resulting in a felony charge, but typically those lower weight amounts do not. So with all of that, Your Honor, I would ask that he be released on his own recognizance, again, given his other holds, and most likely misdemeanor related charges resulting from this arrest, and his stable employment and residence, as well as a phone number. If those other holds are lifted, he could be subject to pretrial services check-ins and testing in order to ensure compliance with the laws, as well as his appearance at future court dates.
Thank you. The court has considered the arguments of the parties. I had intended to set $5,000 bail, but the state's not asking for that much. And Ms. Cook, I am persuaded in part by your argument. However, I do find that given the risk of non-appearance, which is significant in this case, the pending active warrant, it is necessary to set some monetary amount of bail. Therefore, bail will be set in the amount of $2,000 by surety or 10%. If he posts, he needs to check in with pretrial services and be supervised. He'll also be subject to testing for controlled substances at random. His next court date will be a 72-hour hearing on July 18th. It says 18th.
Oh, I think that was an clerk error from yesterday.
Oh, all right. July 17th, it says 18th in the docket, but it's the 17th. I believe that concludes the calendar.